If you have a family member waiting outside the United States right now for a visa, or if you are a green card holder who has been petitioning for a spouse, a child, or a sibling for years, what I am about to tell you in the next few minutes could fundamentally change your understanding of where things stand and what you need to do right now. Because something has shifted in the way family-based immigration is being processed, prioritized, and discussed at the highest levels of U.S. immigration policy. And if you are not paying attention, you could miss a window that may not stay open for long. Stay with us. Do not close this video. This is Legal Focus USA, and this is exactly the kind of update we exist to give you. Welcome to Legal Focus USA, the channel where we break down U.S. immigration law and policy in clear, factual, and actionable terms. We are not here to sensationalize. We are not here to give you rumors or political commentary dressed up as legal analysis. Everything you hear on this channel comes from verified legislative developments, official agency guidance, federal regulatory processes, and court decisions that we track continuously so that you do not have to. If you are new here, subscribe right now and turn on notifications, because the information in this video alone is something that millions of families waiting on family visa petitions need to understand today. Now, let's get into exactly what is happening, why it matters, and what you need to do about it. Family-based immigration is the backbone of the United States immigration system. More green cards are issued through family petitions every year than through any other category. And yet it is also the category most plagued by delays, backlogs, bureaucratic bottlenecks, and a visa quota system that was designed decades ago and has struggled to keep pace with the scale of demand. Families have been separated for years, sometimes for over a decade, while petitions move through a system that was never built for the volume it now carries. But in 2026, there are real and significant developments affecting how family visa petitions are being processed, how priority dates are moving, and what steps families can take right now to position themselves as favorably as possible within the existing legal framework. Here is what many people are misunderstanding about the family visa system, and this is foundational to everything else we are going to cover today. The family-based immigration system operates through two distinct legal tracks. The first is what is called the immediate relative category under INA Section 2011B. Immediate relatives of U.S. citizens, which means spouses, unmarried children under the age of 21, and parents of adult U.S. citizens, are not subject to annual numerical limits. There is no visa cap on this category. There is no priority date waiting period. The only delays in immediate relative cases come from processing times at USCIS and, where applicable, at the National Visa Center and U.S. consulates abroad. This is critically important because many people who fall into this category are waiting unnecessarily, either because they have not filed the initial petition, have not followed up appropriately, or are unaware of what stage their case is actually in. The second track is the family preference category system. This is where the real backlog lives. Under INA Section 203A, Congress established 4 family preference categories. F1 covers unmarried adult sons and daughters of U.S. citizens. F2A covers spouses and children of lawful permanent residents. F2B covers unmarried adult sons and daughters of lawful permanent residents. F3 covers married sons and daughters of U.S. citizens, and F4 covers brothers and sisters of adult U.S. citizens. Each of these categories is subject to an annual numerical cap, and because demand for these visas, particularly from countries like Mexico, the Philippines, India, China, and El Salvador, far exceeds the annual supply, beneficiaries must wait for what is called a priority date to become current before they can take the final steps toward receiving their visa. This is where things become critical, because the movement of priority dates in the Visa Bulletin, which is published monthly by the Department of State, is one of the most consequential and least understood mechanisms in the entire immigration system. And right now, in 2026, the movement in certain family preference categories is creating opportunities that families need to understand and act on quickly. Let me give you a picture of what this looks like in human terms. Think about someone like Anna. She is a U.S. citizen who filed an I-130 petition for her younger brother Eduardo more than 12 years ago. Eduardo lives abroad, has a family of his own now, and has been waiting in the F4 category for what feels like his entire adult life. The priority date for Eduardo's home country in the F4 category has been moving slowly and unevenly, but it has been moving. And recently, USCIS and the Department of State have been working through mechanisms within the existing regulatory framework to accelerate the processing of cases where beneficiaries are documentarily qualified and ready to move forward. If Anna has not updated Eduardo's National Visa Center file recently, if contact information has gone stale, if a document has expired, Eduardo could miss his window when his date becomes current. And in the family preference system, missing your window when the Visa Bulletin finally aligns does not just mean a delay. It can mean years of additional waiting. Or consider someone like James. He is a lawful permanent resident who received his green card 3 years ago and filed an I-130 for his spouse Claudia, who is still abroad. James is in the F2A category. And here is something that James may not know. The F2A category has historically been one of the fastest moving family preference categories. And there have been periods, including recently, where the F2A priority date has either been current for all countries or close to current. If James has been passively waiting without monitoring the monthly Visa Bulletin, without updating his case at the National Visa Center, and without understanding what he can do to keep his file active and complete, he could be creating unnecessary delay in a category that should move relatively quickly. This part could affect you even if you think it doesn't, because the question of whether your family petition is positioned to take advantage of favorable Visa Bulletin movement is not just a passive waiting game. There are active steps that petitioners and beneficiaries can take to ensure their cases are ready to move the moment their priority date becomes current. And failing to take those steps is one of the most common and most costly mistakes in the family-based immigration process. Now let's talk about what is actually happening at the policy and legislative level in 2026 that gives this video its urgency, because I want to be precise with you, as we always are on this channel. There has been sustained and bipartisan pressure in Congress to address the family visa backlog through legislative reform. Various proposals have been introduced that would take different approaches to the problem. Some proposals focus on recapturing unused visa numbers from prior fiscal years, which would be a significant development if enacted. Under current law, if annual visa numbers go unused in a given fiscal year, they do not automatically carry forward. Proposals to recapture those numbers and apply them to current backlogs have been introduced in multiple legislative sessions. If such a provision were enacted into law, it could dramatically accelerate priority date movement for families in certain preference categories. But here is what you must understand. These proposals are not yet law. A proposal being introduced in Congress, or even passing one chamber, does not change the system. For any legislative reform to take effect, it must pass both the House of Representatives and the Senate, where most substantive legislation must clear the 60-vote filibuster threshold unless it moves through the budget reconciliation process, and then it must be signed by the President. That is a significant procedural bar. And the history of comprehensive immigration reform in the United States is a history of proposals that generated enormous attention and hope without ultimately clearing all of those hurdles. However, and this is where you must pay close attention, executive action and regulatory mechanisms provide a parallel path that does not require new legislation. The Department of Homeland Security, working through USCIS, and the Department of State, working through its Bureau of Consular Affairs, have tools within the existing legal framework that can meaningfully affect how quickly families move through the system. The monthly Visa Bulletin itself reflects decisions made by the Department of State about how aggressively to advance priority dates. USCIS has policy discretion in how it allocates adjudication resources, and both agencies operate under appropriations from Congress that affect staffing levels, technology investments, and processing capacity. In 2026, there are operational changes at USCIS that are affecting processing times in ways that both help and complicate family visa cases. On one hand, certain field offices and service centers have made measurable improvements in processing I-130 petitions. On the other hand, interview requirements that had been waived in certain categories during prior administrations have in some cases been reinstated, adding steps to the process that previously moved more smoothly. And consular processing, which affects beneficiaries abroad, remains constrained by appointment availability at U.S. embassies and consulates, many of which are still working through appointment backlogs that accumulated during the COVID-19 pandemic and have not fully resolved. But here is a serious catch you need to understand. There is a specific mechanism in the family-based system called Visa Bulletin cutoff date management, and it can work against families who are not paying attention. The Department of State publishes 2 sets of dates in the monthly Visa Bulletin: the final action dates chart and the dates for filing chart. In months when USCIS determines there are sufficient visa numbers available, it allows applicants to use the more favorable dates for filing chart to submit certain adjustment of status applications. This means that in some months you may be able to file your I-485 application to adjust status to permanent resident before your final action date is technically current. This is an important tool, but it is only available in certain months for certain categories, and USCIS announces which chart is operative each month on its website. Missing a month when filing is authorized, particularly in slower-moving categories, can add significant time to your case. This is where things become critical for your immediate action plan, because understanding the Visa Bulletin and knowing how to read it is not optional if you have a family member in a preference category. It is one of the most valuable skills you can develop as someone navigating this system. Let me now walk you through exactly what you should be doing right now, regardless of where you are in the family petition process. If you are a U.S. citizen or lawful permanent resident who has not yet filed an I-130 petition for a qualifying family member, file it now. The priority date that USCIS assigns to a family preference petition is the date the petition was received. Every month you delay filing is a month added to the front of your family member's waiting period. The I-130 itself does not cost you the immigration journey. It simply establishes the priority date. And in categories where waiting periods are measured in years or even decades, that date is everything. If you have already filed an I-130 and your case is pending or approved and waiting at the National Visa Center, log into the NVC's CAC portal and verify that your case is documentarily complete. Confirm that all required civil documents have been submitted and accepted, that your affidavit of support is current, and that your contact information is accurate. Cases that go dormant at the NVC because of outdated contact information or incomplete documentation can be administratively closed, meaning they effectively disappear from the active queue. Reopening a closed case requires additional time, additional steps, and in some cases, legal intervention. If your priority date is close to becoming current based on the most recent Visa Bulletin, or if it has recently become current, contact the NVC or your attorney immediately. Do not assume the system will automatically advance your case. The final steps in the process, whether consular processing abroad or adjustment of status in the United States, require active engagement and timely response to agency requests. Here is what many people are misunderstanding about this stage. Receiving an interview notice does not mean your case is over. The consular interview or the USCIS adjustment interview is a critical moment in the process, and arriving unprepared can result in a denial, an administrative processing hold, or a request for additional evidence that adds months to your timeline. Prepare for your interview with the same seriousness you would bring to any consequential legal proceeding. Review your petition. Organize your documents. Understand what questions are likely to be asked about your relationship, your background, and your eligibility. If your family member's case involves any prior immigration violations, criminal history, periods of unlawful presence, or prior removal orders, do not attempt to navigate those issues without qualified legal representation. Inadmissibility grounds under INA Section 212 are numerous and complex. Waivers exist for many of them, but waiver applications require careful preparation and a thorough understanding of the relevant legal standards. Filing a waiver without understanding what you are doing is not just unlikely to succeed. It can create a record that makes a subsequent well-prepared application harder. Be aware of scams and fraud. In any environment where families are anxious and desperate for movement, fraudulent actors emerge. They claim to have connections at USCIS or the State Department. They promise to move cases faster for a fee. They operate as notarios or immigration consultants who are not licensed to practice law, but who charge for services they are not qualified to provide. Report these individuals to the appropriate state bar authority and to the Federal Trade Commission. Do not pay anyone for access or influence they cannot legitimately provide. There is no shortcut in this system that a third party can sell you. Monitor the Visa Bulletin every single month. It is published by the Department of State at travel.state.gov, typically in the second half of each month for the following month. Set a reminder. Read the relevant category for your family member's situation and cross-reference it with the USCIS announcement about which chart is operative for adjustment of status purposes. These two pieces of information together tell you where your family stands and what filing options may be available to you in any given month. Consult a qualified immigration attorney, particularly if your case is complex, if it has been pending for a long time, if there are any complications in your family member's background, or if you have received any adverse communications from USCIS or the NVC. Many attorneys offer initial consultations at a reasonable cost. The investment in getting qualified legal advice early is almost always less than the cost of correcting a mistake that could have been avoided. Now, let me bring this home with the broader picture because I want you to leave this video with both a clear understanding of what is happening and a realistic sense of what is possible. The family-based immigration system is under pressure from multiple directions simultaneously. There are legislative proposals that could help but have not become law. There are operational changes at the agency level that are affecting processing in ways that are not always predictable. There are external factors from consular appointment availability to congressional appropriations to court challenges that can affect timelines in ways that no individual applicant can fully control. And there is a Visa Bulletin system that moves in ways that are sometimes faster than expected and sometimes frustratingly slow. What you can control is your own preparedness. You can control whether your petition is filed. You can control whether your NVC file is complete. You can control whether you are monitoring the Visa Bulletin and understanding your options each month. You can control whether you have qualified legal representation when you need it, and whether you are avoiding the mistakes that cause unnecessary delays. And you can control whether you are staying informed through reliable, accurate sources, rather than rumors, social media speculation, or advice from people who do not understand the law. However, this protection is not permanent. The favorable conditions that exist in certain family preference categories right now, the priority date movements, the filing opportunities, the operational improvements at certain offices can change. Policy changes, political environments change, agency priorities shift. What is available to you today may not be available in the same form 6 months from now. That is not a reason for panic. It is a reason for action. Your family is worth fighting for. The years of waiting that so many families have endured are a testament to that. And the families that navigate this system most successfully are the ones who stay engaged, stay informed, and take deliberate action based on accurate information, rather than waiting passively and hoping the system will take care of them. If you want accurate, fast, and reliable immigration updates, subscribe now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional. It's essential. If this video gave you clarity on something you have been confused about, please give it a like. It costs you nothing, and it helps us reach more families who need this information. Drop a comment below telling us what family preference category your case is in, or what stage of the process you are at. We read every single comment, and your questions directly shape the content we create. And please share this video with your family members, with your community, with anyone who is waiting on a family visa petition and does not understand the full picture. Sharing this information could change someone's timeline in a way that changes their life. This is Legal Focus USA.